For 2,000 years, China had no lawyers. Not because it was behind, because it didn't need them. In ancient China, if you wanted to take a legal dispute to court, the first thing you did was not hire a lawyer. You walked to the front gate of the county magistrate's office, beat a drum to announce your grievance, and knelt on the ground to plead your case. No advocate, no defense counsel. Your fate rested on one man's judgment. In the United States today, there is one lawyer for every 300 people. Across more than 2,000 years of imperial rule, China never developed an institutionally recognized legal profession. Not because the Chinese didn't go to court, they did frequently. Not because China lacked laws. Chinese legal codes were more detailed than most civilizations of the same era. The reason is the opposite. The law was too powerful. The question was never whether law existed. The question was, who was using it? In Europe, law gradually became a tool to restrain the king. In China, law was always the emperor's tool to govern the realm. A lawyer can only exist when ordinary people are allowed to use the law. When the law is a blade pointed at you, you don't need a lawyer. You need mercy. Shang made this perfectly clear. The purpose of law was to make the state powerful, not to protect individuals. His system came down to two things: reward and punishment. Perform correctly, get rewarded. Fail, get punished. Almost no room for interpretation. This logic was imposed across the entire country by the first emperor of Qin, inherited by the Han dynasty, and carried forward by every dynasty after, for 2,000 years. Inside this system, a single county magistrate was not just a judge. He was also the prosecutor and the chief administrator. The man who arrested you, the man who tried you, and the man who sentenced you were the same person. Standing before him, you were not opposing him in argument. You were asking him to decide your fate. No adversarial process, no defense procedure, no jury. You were on your knees. The law was not a resource you could invoke. It was a force applied to you. What you faced was not a set of rules. It was power. China was not entirely without people who helped others in legal disputes. They existed. They were called Songshi, litigation masters. But the issue was never whether they existed. It was their position. They drafted petitions and offered advice, yet they were never recognized by the system. Instead, they were widely regarded as troublemakers, parasites who stirred up conflict. Because the Confucian ideal was Wu-sound, a society without litigation. A good society should have no lawsuits at all. The existence of litigation itself was proof that order had failed. Within this logic, helping someone file a lawsuit was not defending justice. It was creating problems. A system that treats disputes themselves as a failure cannot possibly allow the person who resolves disputes to become a legitimate profession. But in Europe, things went the other direction. Roman law developed a concept that Chinese law never produced: the contract. A contract means two parties are equal. You promise me this, I promise you that, and both sides are protected by law. This premise never held in China. The emperor and his subjects were never equal. The Roman Empire fell, but Roman law survived. Medieval European kings needed money to fight wars, merchants' money. The merchants had one condition: you could not default. An agreement signed today cannot be voided tomorrow. My property cannot be seized at will. And so a set of rules began to take shape, rules that even the king had to follow. This was the origin of property protection. When law began to shield individuals from the abuse of power, it stopped being merely a tool of governance. It became a weapon that ordinary people could wield. Someone was needed who understood the rules, could interpret them, and could speak on your behalf in court. The lawyer appeared at precisely this point. The Magna Carta in England marked a turning point. The king was forced to promise that no free man would be deprived of his property or liberty without lawful judgment. This was not generosity. It was concession. Law went from one-directional to two-directional. Place these two lines side by side, and the picture becomes clear. In China, law flowed downward. The emperor made it, officials enforced it, the people obeyed it. At its core, law served order and control. No one could turn it around to constrain the emperor. In Europe, law grew upward. Contract protected individuals. Property rights limited the king. Rules gradually bound power itself. Law slowly became a tool for the weak, to challenge the strong. Direction determined everything. When law pointed downward, what you needed was connections, someone who could speak for you in front of the magistrate. When law pointed upward, what you needed was expertise, someone who understood the law better than you and could defend your rights. When the law is a blade, it points at you. When the law is a shield, it stands in front of you. A blade does not need a shield. A shield needs someone to hold it for you. That person is a lawyer. China itself confirmed this principle. The legal profession formally appeared in China only after the late Qing reforms, when the law introduced the concept of rights for the first time, when it first acknowledged that individuals could use the law to protect themselves. Only then did the profession have a reason to exist. When the direction changed, the role appeared. For 2,000 years, China had no institutionalized lawyers. This was not a deficiency. It was a consequence. The direction of law determines who is allowed to speak and who must remain silent. This principle has not expired.